Thank you all for your patience and welcome. We are excited about you attending our second NACRA webinar. In case you don't know, I am Luana Panasco and currently starting my second year as NACRA president. Our topic today is finding stability, understanding governance and financial risk in CCRCs. We're excited today to have on our expert panel Yvonne Troya, elder law attorney and author of Exercising Control or Giving It Up, What Elder Law Attorneys Should Know About Continuing Care Retirement Communities. Also with Yvonne is A.V. Powell, nationally recognized actuarial consultant on senior living finances. And a third party joining our discussion today is another expert, Catherine Pearson. Catherine is so well known for her deep experience in the field of elder law and is the author of articles and book chapters on long-term care, financing issues, and filial obligations. And we're going to begin this seminar with a 20-minute slide presentation narrated by our NACRA board member, Dan Ancona. After the slide presentation, I will introduce Catherine and she will open the discussion with a couple of slides for context as well as talk about a breaking story on Spirit Trust Lutheran and their Chapter 11 reorganization that will take place this fall in Pennsylvania. So let's start the slideshow.
Welcome and thank you for joining us. Today we will be discussing the evolving business of life plan communities, sometimes referred to as managed communities for seniors, or more commonly called continuing care retirement communities, CCRCs. Our goal is to help you better understand the risks and the safeguards that shape residents' long-term financial security and quality of life. This webinar is brought to you by the National Continuing Care Residents Association, NACRA. Over the next 20 minutes, we'll look closely at how senior living and life plan communities are evolving and where some have stumbled. Most importantly, we'll explore how residents can play a more empowered and informed role in guiding the future of their communities. We'll begin by discussing 3 troubling stories about real-world communities, then look at the role of residents in the basics of governance and finance, and close with practical tools and opportunities for action. The first case we'll look at is Amsterdam at Harborside, a luxury CCRC located on Long Island that has filed for bankruptcy not once, but 3 times. Residents paid up to $1.7 million in entrance fees, expecting a lifetime of care. But in the most recent collapse, more than 180 residents lost millions in evaporating refunds. Memory care services were discontinued, and promised services were no longer available. Now, the bankruptcy resulted from various factors, including the impact of the pandemic, and on rent entrance fees being paid by new move-ins being used for operations and debt service. Harborside also had trouble recruiting new residents due to the extraordinarily high entrance fees ranging from $425,000 to $2.3 million, depending on the unit that was selected. Bankruptcies in this sector are statistically rare, less than 0.1% of all CCRCs nationwide. But for the thousands of residents caught in them, the impact was devastating. According to Wall Street Journal review of court filings, at least 16 CCRCs, including Harborside, have filed for Chapter 11 bankruptcy since March of 2020. These bankruptcies wiped out over $190 million in savings for more than 1,000 families, including 212 at Harborside. While bondholders were expected to recover around 50 cents on the dollar, residents and families of deceased residents receive only partial reimbursement of entrance fees, with an estimated distribution between 25% and 33%, which translates to roughly 25 cents on a dollar. The Harborside case highlights the vulnerability of residents' assets in such situations. The problem is bankruptcy law prioritizes secured debt over entrance fees. Consequently, residents are among the last and the least to receive a settlement. But on the positive side, in many cases, bankruptcy can be avoided or settled by a merger of acquisition. But this too can have risks, as you will see in the next example. In the next case, residents in River Glen at St. Charles, Illinois, thought this would be their forever home. This senior living community outside of Chicago had units for independent and assisted living and for memory care. It seemed stable until it was sold to a group of private firms. NBC News came in and interviewed residents who reported that when the new owners took over, monthly maintenance fees quadrupled, rising from $1,395 to over $6,000 a month, effectively forcing them to move out. And the promised refund of entrance deposits of 85% were cut to 75%, resulting in a $100,000 loss. Now, this was not a bankruptcy. It was an acquisition, but the outcome was the same. Residents were severely hurt financially. Honestly, sometimes a CCRC rescued from financial collapse by a merger acquisition transaction. But at other times, these deals feel more like raids where promises made to residents are unilaterally changed or voided. The owner makes a profit while the residents bear the financial loss and decreased services. We call this dilemma rescued or raided. For the next example, this is Rogue Valley Manor, a not-for-profit CCRC located in Medford, Oregon. In 2012, the residents of Rogue Valley began to suspect that management was using their funds from entrance fees and monthly fees for other businesses. They discovered that their money was used to help start 2 new CCRCs located over 300 miles away in Portland and Seattle. Now, it was not difficult to see how these distant facilities offered no benefit for Rogue Valley residents. So the residents sued the management company, and after months of negotiations, the residents' attorney announced that Rogue Valley Manor Residents Steering Committee had accepted a settlement offer by the management company, enabling the parties to avoid class action litigation. The settlement gave the community an independent board of directors that included 2 residents as voting members on the board, limitations on the operator's ability to remove directors from the board, and capped management fees for 3 years. Additionally, $400,000 in monthly fees were credited back to Rogue Valley residents. The nursing home sector is being especially impacted. Professor Catherine Pearson from Penn State's Dickinson Law School recently noted in an editorial in the Pittsburgh Post-Gazette that private equity is reshaping the elder care landscape, resulting in over 20 bankruptcy filings of elder care facilities in the local area. Private equity firms extract money from nursing homes in a process called sale-leaseback, or selling the land out from under the facilities for a lump sum payment. Then the nursing homes must pay rent or management fees to occupy the facilities that they once owned. On a positive side, though, some senior care businesses have quietly been absorbed through mergers or acquisition transactions, providing stability, but others result in chaos and financial loss for residents. The question becomes, was it a rescue or a raid? Let's look at a bit of history. Early CCRCs did not start as businesses. They were religious or fraternal roots. They were built on community trust and a spirit of mutual care. Such communities were often called old people's homes, established to care for retired clergy, military, or members of fraternities or their widows. They were funded by contributions from members of a larger denomination outside of the residents in the life care facility themselves. But in the 1970s and 80s, a different concept emerged in life care communities that were fully funded by entrance fees and monthly charges paid by the residents themselves. Unfortunately, one legacy from the early history is the pattern of governance throughout the industry that presumes that residents are passive recipients of charity. The CCRC market has changed again. Entering residents today are younger, smart, skilled, and many are anxious to be involved in the governance of their communities. In addition, residents who pay large entrance fees and ongoing monthly service charges think of their role as stakeholder, not as a tenant. A major investor and partner in the community, residents expect transparencies and accountability. In addition, investors expect to have the right to an active role in decisions for the community's operation and financial affairs. There is a growing shift away from the hospitality-oriented paradigms towards this partnership between residents and management. Communities that recognize this mind shift are taking advantage of this change by increasing resident engagement and freedoms. These communities are more likely to thrive. Now, in the next section of this presentation, we'll focus on understanding the economic risks and the elements of CCRCs, that contracts and governance procedures. Business experts remind us that every life plan agreement is actuarial at its core. Residents pool resources inside a corporate entity much like an insurance pool. The idea is that invested contributions more than cover daily living, health care, and build reserves for unpredictable events. If the math holds, the pool remains stable. But actuarial models are only projections. If residents live longer than expected, or if more people develop chronic conditions, or if nursing care demand spikes, or if the stock market drops, decreasing investment returns, the costs can exceed the plan. Now, unlike GAAP accounting, that's general accepted accounting practices, actuarial analysis can assess the level of reserves needed to weather potential risks. Now, there are a wide range of risks, as shown here on this slide, that boards, community leaders, and residents should consider. Some are personal, some are temporal, structural, economic, regulatory, and even the weather. To assess these risks, some progressive and wise community operators do financial stress testing in their business planning. As an example, if a housing market slows and prices drop, prospective residents may be unable to sell their homes, reducing cash available needed for entrance fees. Now, an elder law attorney or professional planner can provide valuable help in assessing, planning, and evaluating these risks. Realistic understanding of risks and residents' rights is critically important. Some residents falsely feel like they have purchased a home and a promise of continuing care. But in reality, legally, most CCRC contracts are simply residence and care agreements, operative word agreements, that are not at all like a contract for purchasing tangible real estate ownership. And in most cases, residents have no say at all in changes to the agreement. The bottom line is that life plan agreements are both actuarial and cultural. They succeed only when the finances are sound and the mission stays true. Here again, professional advice can be invaluable. An elder law attorney can help determine whether changes remain consistent with the contract or whether residents' rights are being eroded. Now, in some states, they have an official complaint procedure, but typically these state agencies have no enforcement authority. So in serious cases like Rogue Valley, legal action may be necessary and can be successful. Now let's talk about organizational structure. In most CCRCs, they are governed by a board of directors. In some communities, residents serve on the board, but in many cases, the board governs with little or no direct contact with residents. Consequently, their financial decisions may prioritize business benefits over community stability. And administrators are under limited obligation to disclose financial or strategic direction of the organization. In many cases, the board will hire an operating company to provide community services including food, transportation, facility maintenance, and operations, sometimes for multiple communities. This structure has advantages of centralizing procurement, economies of scale in purchasing, and possibly labor savings. However, it adds a level of isolation from the residents who are using these services. Consequently, residents may be seen as customers, not as partners in the operation of the community. Residents need a voice and transparency as safeguards. NACRA strongly advocates that community corporate boards include at least 3 full-time voting resident directors. Candidates should be selected by the resident council, not by the seated board, and resident directors should be free to share information with the community, while of course protecting confidential or proprietary business information. The rationale for enrolling resident directors is to provide a direct stakeholder voice both to and from the board, to draw on the rich talent pool of residents in a community, to be accountable to both residents and the business, to improve transparency, and to encourage buy-in on board decisions and policies. So, are you ready to take action? If so, NACRA offers an array of educational and practical tools to help. Publications include NACRA's Consumer Guide that helps residents evaluate and understand contracts before signing. NACRA's Financial Soundness Handbook helps residents make sense of community financial reports. There are links to other organizations' publications like the National Academy of Elder Law Journal, including an article by Yvonne Troya, What Elder Law Attorneys Should Know About CCRCs. NACRA also offers a forum that's a vehicle for raising and discussing issues with residents and with other organizations. The access to NACRA's site is free and it's open to the public, but there are members-only sections for sensitive subjects. Together, these tools can help you ask better questions and demand clearer answers. An especially important item on the NACRA website is the Model Bill of Rights for Residents that aims to ensure balance and transparency. It lists 17 topics, including core principles such as the right to organize, the right to transparent financials, the right to elect resident directors, and the right to be consulted before major changes are made to a community. Now, since our time is limited, we won't review all 17 items on the list, but these are not luxuries. They are the foundations for trust. In conclusion, we residents are not passive tenants. We are partners in the communities that we live in and call home. By understanding the CCR business model, demanding transparency, and advocating for reforms, we can protect what matters the most: trust, care, stability, and community sustainability. NACRA invites you to participate locally, regionally, and nationally. We are of residents, by residents, and for residents. Thank you for your attention and commitment.
Thank you, Dan, for that presentation. And thank you for wrapping it up since we did get behind a bit. And I want to remind everyone that we welcome your questions and we want to make this a conversational format. So after we begin the discussions with Catherine, please, if you have questions or want to make comments, raise your electronic hand that is available at the bottom of your Zoom screen. If you're on Zoom, if it's not visible, it also is there under the More button where you have the three dots. But please raise your hand so we can recognize you and we can bring your comments and concerns into our conversation. At this time, I'd like to recognize Catherine to start her presentation, and she's going to give us a couple of slides leading into her discussion regarding the Spirit Trust reorganization in Pennsylvania that is scheduled to happen this fall. Catherine, please take over.
Thank you so much, Luana. And thank you also, Dan. That was a great presentation. And it was so nice to hear history of some of the communities that I'd worked with in the past, including Rogue Valley. And let's go right to the second slide. There we go. Yeah, well, that's fine. We can, yep, there you go. Very good. So, so much of what was discussed already is included in this slide. The one thing I love about talking to members of NACRA is you are sophisticated consumers. You're not the brand new consumers for CCRCs. You're the sophisticated consumers, and that's really helpful. The one thing I'm going to talk slightly about basic concepts is how they are changing. So one of the trends I'm seeing is that whether you call them CCRCs or life plan communities or any other label, I began recognizing when Leading Age proposed the name change from continuing care retirement communities to life plan communities, that it was more than just an argument that they were making that people prefer to have something that doesn't refer to care as the name of their community. I don't think residents are that simplistic about why they that they were supporting the name change. I think that was what the communities were recognizing, is that care is expensive, and that by calling them life plan communities, they could emphasize a long-term model, but not necessarily tied exclusively to care. So that's my personal opinion. I've never heard anybody in the industry admit it, but I think that we need to be realistic when we see changes in terms all the time in the world of senior living in general. Terms are always important. So in the contract world, which is what I'm really going to be talking about, the reason why I teach contract law, have taught it now for the last 10 plus years, is because of continuing care retirement communities. I was seeing so many things happening that were curious to me as somebody who studies contract law. And it's just, CCRCs have taught me so much about what can happen with contract law, both good and bad. One of the things that, we always need to remember is that the contract involves an exchange. So on the one hand, there is some kind of a promise of services, and the residents have promised to pay, and they've already paid, believe me, by the time they get to the point of living there, and are going to keep paying. But that quid pro quo, that negotiation, that exchange of compensation really is a key component. And I'll keep talking about that as we go. I also say that when people are going into communities, make sure you keep a copy of your original contract. Somebody may argue your contract has changed, but keep that original contract because you may be arguing it has not changed. The other thing is save all papers that are marketing materials, because sometimes a lot of key implied promises or actual promises are made during marketing. And if you keep those documents, you might be able to argue that they were a component of the agreement and that those marketing materials should also be used to understand what the agreement was. Let's go to the next slide. The one that says some additional thoughts. Okay, so today what I'd like to talk a little bit is I'm going to drill down into what I'm seeing with contracts. One of the things I tell my law students is that the contract is king in many relationships, and certainly in CCRCs, the contract is king. Sometimes residents want to argue that the state's regulation is the controlling factor, but that's not usually true. Almost always the state has given the CCRC enterprise the ability to shape and frame and control its own life with the residents as the other side. So the contract is king. I say here that CCRCs use contracts to anticipate and plan for risk. Frankly, that's true with all commercial enterprises. That's why they use written contracts, to anticipate and plan for risk. But in the consumer context, it becomes a little warped, because generally the consumer does not have free rein to negotiate that contract. So that's why I believe it is important to have state regulation, just as you have in other areas for consumer protection law. The contract is king, though, in absence of some statutory difference. We also are going to look a little bit at Chapter 11 and how that changes the contract world. Don't go there yet, please.
Okay, sorry.
Yeah. We'll get there in a minute. Okay, so one of the things I also try to emphasize is many residents who are brand new to CCRCs, sometimes even those who've lived there for a year or two, will tell me that all of their entrance fees were escrowed or reserved. And generally, that's just not true. Sometimes what they're referring to is an escrow that was for an application fee that often is escrowed, put in a separate account that has limited purposes, and you get it back if within the context of the rules for application, you get it back. If they say you get it back, you get it back. So that's an escrow account. It's usually short-term, limited purpose. Reserves are different. Reserves are a concept that really ties beautifully in with actuarial concepts, because normally you're talking about what reserves should be recognized. Reserves can be a mere notation on accounts. It may not be an account at all. It may be a bookkeeping entry. So there may not be an escrow account the way there is with escrows. So be careful about not confusing those two terms. The other thing I say is to look for any restrictions, or for that matter, lack of restrictions, on CCRC's use of the fees paid by the residents. More and more, what I'm seeing is it's often not in the first 2 pages of the contract, maybe not even in the first 5 pages of the contract, but someplace there's going to be a long paragraph describing what limitations, if any, there are on the community's use of the fees by the CCRC. Often you will see that the CCRC can use the monies paid for any purpose. Sometimes they'll have one definition for the entrance fee, sometimes a different definition for monthly service fees, but that's becoming important language. Look for cross references between the contract and what I call non-contract documents that they might try to incorporate by reference, usually handbooks. Sometimes they will put all the unrestricted use language in the handbook. I'm not a big fan of that. That's something that's a spillover from labor law, and there's lots of cases about that. But generally speaking, that's a rather new concept I'm seeing in CCRCs. Look for choice of law provisions. Will your contract be interpreted by the law of the state in which your CCRC is located? One of the things that we learned in one of the big bankruptcies back in 2008 and 10 was that many of the contracts specified Texas law as controlling. And they took the CCRC bankruptcies, the Chapter 11s, to Texas for really important reasons. Texas law has some unique approaches to a Chapter 11. Often healthy approaches. They work pretty fast and they're sophisticated bankruptcy court, but sometimes you think you have protections and it may actually have been changed by the contract choice of law provision. And then finally, how are refundable fees handled? In sometime after the 1980s, refundable fees began to appear. Somebody who is a friend of mine, a lawyer who was working for a big firm, said the reason why they were designing refundable fee contracts was to attract new customers who were nervous about bankruptcies in the 1980s, where residents were losing their entrance fees entirely, and sometimes having to pay additional upfront fees. So the refundable fee concept was offered as a way to say, well, look, you're going to get it back, at some time in the future. Usually the time is when you either die or pass away, or you've moved out, and you would get it at that point. But the concept of refundable fees has just grown and grown, and there's like all these different versions of them now, often with unique names. Be careful of the names. The names may sound great, but read them carefully. Figure out, compare between different communities to see what you're looking for or what you're obligated to. And then what I'm looking at is, does the contract promise or even use the word guarantee? Some of the rare times when they will use guarantee is when they're talking about when will the refundable fees be repaid. If they actually say guarantee, that's great. But usually they just say they will be repaid when X number of days after the death or departure of the resident. If you see that language about timing, that's good. That's good, generally speaking. A lot of times what you'll see is that the contract says refundability is tied to resale of the unit or some other language meaning that your unit goes to a new resident. And often without any priority that will make your unit's repayment to either you or your heirs happen until your actual unit is resold. And quite frankly, many communities may have little incentive to resell your unit if they have new units that have no refundable fee, tied to that unit. You may be at a bottom of a priority list that you don't even know exists. So be aware of that up front. One of the things that we're seeing is states effectively responding to this with state law. So New Jersey is probably the number one community or number one state that has had good resident organization through NACRA and its state chapter Orange. And they have achieved a statutory agreement. Really, it was an agreement. It was a statutory, change, but it was also the industry more or less agreed to it. On a first out, first to be repaid basis. So even though your unit, may not have resold, is creating a priority list that favors the first to leave is the first to be repaid, no matter which other unit is eventually sold in that community. So keep an eye out for that kind of language. At the same time, New Jersey did something that I think is an indication of what's happening in this marketplace. There was a new bill. I think it's still, I think it's still pending, but I don't think it will ever be voted on, or at least it won't be passed. Where, in addition to first out is the first to be repaid, there was going to be a number of days or months. I think they tried to go with a year. So the refund would have to be paid within a year of the resident leaving. And the Leading Age, the organization that advocates on behalf of CCRCs themselves, was able to convince the legislators and most residents to drop that year maximum on the argument that that puts too much pressure on a CCRC that might be having financial soundness troubles. Let them work it out. Don't limit them in a way that's going to cause a financial break that they don't want. Yeah, I'm seeing that D is pointing out in the notes here that it was not successful and did not pass there. And residents actually ended up agreeing to drop pushing for it, I think.
Hey, Catherine,
So-
can I add something about repayable on resale fees? So we're seeing this as a trend of moving towards the repayable on resale and away from refundable entrance fees. So this is definitely happening in California and all over. And I had spoken to an investment banker whose bank underwrote bonds for nonprofit CCRCs, and she said that she would be surprised if any CCRCs were offering truly refundable contracts these days. So they really work to shift the risk onto the resident, because the resident has to wait until the unit gets resold to recover. But and also in California, the repayable on resale entrance fees are not kept in the refund reserve, which California does have. But I did want to point out that California has some protections now, and it's because of resident activism. It's because of CalCRA, the California Association for Residents, and Canner too. So you have to really have to engage with the local resident associations. They can do so much, but in California. Now there is a requirement that the CCRCs have to pay interest. So it starts at I believe it's 4% interest if it takes 6 months or more for the unit to sell, and then it goes up to 6% interest. So there is some financial incentive for the CCRC to actually get a move on it and sell that unit.
Very good. Yes, California has been another one of the states that's had good success with resident advocacy. And kind of the two states on opposite ends of the country have had particularly good success in that way. I'm still seeing contracts that do have separate promises about when the refunds will be repaid. So I'm still seeing them in Pennsylvania. So maybe they shouldn't be doing that, but I'm seeing that they are still doing that. So it's variable about around the country, particularly about the strength of the community, of CCRCs as a marketplace. May depend on how often you see that. Okay, let's go to the third slide. Okay, so as was presented by NAPRA at the beginning this time, we are looking at a probable new Chapter 11 filing of 6 related CCRCs in Pennsylvania. Spirit Trust Lutheran is the parent company's name, and they have 6 CCRCs in central Pennsylvania. In fact, very close to me, kind of all around Cumberland County, but I don't think there's one in Cumberland County, but south central Pennsylvania. And they have done quite a bit of, transparency meetings, community meetings with the residents so that they understand what might be happening. We don't know yet exactly what's going to happen. The good news is that it looks like Spirit Trust Lutheran has negotiated successfully with a new to be owner from New Jersey, another Lutheran group, that will become the new owner of new parent for these 6 communities. That may not happen, it may, but they are certainly offering this as an agreement, a proposed plan to the bankruptcy court. At least that's what they're saying in advance of the actual filing. So everybody, I think, here knows what insolvency is. It's the inability to pay debts as they become due, usually because of either a cash flow insufficiency, that is often a problem, or bankruptcy, or a balance sheet where the assets, all the assets do not cover the debts that are available on the accounting records. A lot of communities do resolve these kinds of problems quietly, informally, outside of the bankruptcy court. And one of the challenges of that, we don't always know about that. So, but that's good. If they're resolving it and resolving it quickly, that's usually good. In some states, the process may involve a formal receiver. In some, North Carolina is one of the states that recently used a receiver to act as the controlling management company for the CCRC during the negotiations. That can be a little bit more costly for the community to do that. You're paying the receiver rather than paying the original management company, but that sometimes happens. However, the big one is Chapter 11 under the bankruptcy court. That's where, if they can't resolve it informally, if they can't resolve it with the state's, supervisory help, it may have to go to the bankruptcy court for a formal reorganization. In the great world of bankruptcy, Chapter 11 reorganizations are probably, and I'm not talking about just CCRCs, but all reorganizations, probably 15% of them are successful in keeping the enterprise alive. I think the likelihood of the enterprise being kept alive with a Chapter 11 bankruptcy for a CCRC that comes in with a new buyer is probably higher. They have a higher success rate. I don't know that for sure, but I think that's true. Mainly because they've got realistic parties coming in with a similar nonprofit mission. And most Chapter 11s are not involving nonprofit organizations. They don't have that mission-driven goal for solving the problems. I'm going to just walk through a few key terms because I think a lot of people aren't always aware of them. The debtor is the CCRC. A debtor in possession is the CCRC that's going to stay in operation of their own community during the Chapter 11 proceedings. So debtor in possession is not a bad name. It just means that they're not putting in a trustee or a receiver to operate it rather than the original company. Creditors are obviously the people who care about what happens in the Chapter 11, because the question is how many of them are going to be paid what they think they're owed because of debts from the CCRC to the providers. So usually you have vendors, people who are doing laundry for the community, selling food to the community, doing construction projects for the community. Usually that's a big category, construction. Those are probably going to be vendors. They're going to be financing companies usually. So the bond companies, the bondholders, those investment banks, they may be, part of the creditors. And they're almost always, I can't imagine I've ever seen a lender that's not a secured creditor. So they have a contract giving them, a specific protection for their debt as a result of the fact they've loaned money to the community in a formal way. And then residents. Residents are in, as has been already said, they're in this unique status, and because they pay an entrance fee, they often think they should be in a secured status, but they're not a secured status because that fund is not considered to be a loan. Maybe it should be. Maybe we need to recharacterize that. There's an article that was written by Natalie Martin, almost 25 years ago, that suggested that they should be treated as secured creditors, but it really required a change in bankruptcy law to make that happen. So it hasn't happened yet. The trustee, you can appoint a trustee. The court can appoint a trustee. They would take over for the debtor, and that would eliminate the debtor in possession, or at least put somebody watching over them personally. That can happen too. And then the U.S. Trustee's Office, which is separate from the trustee. They are not the same thing. Usually the U.S. Trustee is kind of a watchdog for the whole process of Chapter 11s. And so they may also appear at hearings and in meetings with the Chapter 11 bankruptcy for CCRC. Probably the first thing that's the most important thing we look for are the disclosure statements. So at the time of filing the Chapter 11, one of the obligations of the debtor is to have a sworn statement of what the debts are. A lot of times it's the CFO or the CEO that's going to be the signer of that document. It's usually long, and boy, that's what we really want to look at carefully. And compare it to if it's a nonprofit organization, compare it to the 990s, because we'll see how much debt truly is there versus how much debt we might have thought was there. That can be super interesting. The next step is going to probably be that there's going to be committees created for the creditors. The court actually can put all unsecured creditors in one committee. In CCRCs, the trend has been to put residents in a separate committee of creditors. There might be vendors who are unsecured creditors, but there might be residents as a separate unsecured committee of creditors. And then, of course, there'll be the secured creditors separately from them. Why? Because they have different arguments and different interests that they can make about why they should be repaid, why they should be protected in any reorganization plan. I say in this slide, is there a prepackaged plan of reorganization being announced by the debtor as the plan to solve this problem under Chapter 11? We hope so, because that's usually the best outcome, because they've sat down and worked with companies or worked with enterprises or worked with nonprofit groups, whatever they're working with, and that company is doing their due diligence about what the debts are, and they're saying, okay, we can help with this, we know how to do this, we can do a turnaround here. And so Erickson is probably, one of the most successful, prepackaged plan of reorganizations I've seen. The bankruptcy court in Texas, when it was happening, it was, I think, 11 different CCRCs. It might even have been more than that. Said it was actually the most complicated bankruptcy they'd ever seen. Not just the most complicated CCRC, but the most complicated bankruptcy they'd ever seen. But Redwood came in, and they were the new owner, and it was so successful they were even able to keep Erickson's senior living name for the ongoing enterprise, because it had a good reputation up until that 2008, 2010 financial crisis that affected many people, not just CCRCs, many organizations, not just CCRCs. One of the things that's important for residents to recognize is that creditors committee, the unsecured creditors committee, is the vehicle by which they will be doing negotiation, and they will be voting on whether or not they approve a proposed plan. So there's going to be a committee. I know Jennifer Young. I think I saw Jennifer Young. She was, I think, part of one of the Texas, or at least observed one of the Texas Chapter 11s, and she knew about those committees and the unsecured creditors committee and the roles that they played. One of the things that I think is important, and this is reassurance. Chapter 11 does not have to be, a failure. Chapter 11, rightly done, is going to be a success. And let's hope that happens. But the other part of it is many residents get afraid of the costs associated with the Chapter 11, and there are costs associated with the Chapter 11. But usually what's going to happen is the creditors committees, the unsecured creditors committees, are going to have an attorney and maybe an accountant. And those professional fees are going to be paid out of the debtor's estate, out of the money that the debtor still has available to make this a going enterprise. So that means that usually the residents don't have to come up with their own fees to pay an attorney. They can have their own attorney if they want one. Don't do that, probably, because that's, you're just adding on money to your own concerns. But be aware that the bankruptcy code itself makes a provision for paying reasonable fees to professionals out of the debtor's estate. And then finally, there are two different general varieties of approved plans. One of them is that the CCRC is going to be quickly resold to the pre-selected company. Or if there's more than one, bidder, more than one company that's interested, or maybe there's just too many objections to the original company. That happened in a Pennsylvania CCRC bankruptcy a number of years ago. They didn't like the first proposed company, and so it ended up going to a bidding process. That can be one way that the new owner comes in. Or sometimes what will happen is that the original debtor comes up with a viable deal. The lending companies, the bond companies are going to take some type of a haircut, some type of a new deal that will extend their time for repayment. And everybody says, okay, we can live with this new plan, and they walk off, and that's the end of that. Do we know what's going to happen with Spirit Trust? We don't know yet. We know that they have a proposed viable candidate for the new owner, another Lutheran group out of New Jersey that has experience. I don't even know yet if they're going to file in Pennsylvania or not. I assume they are going to, but I actually don't know that yet. So that's where I'm going to stop.
Well, thank you very much, Catherine, for that in-depth explanation that makes something that is very complicated in language that we understand. At this point, we've actually gone just over our hour. And I just want people to know that if you have a time constraint, if you need to leave, feel free to leave. But because we got a late start, I'd like to continue the conversation. I see hands going up, so please, if you'd like to stay, ask questions, involve yourself in the conversation, stay with us. We are going to continue. So anyhow, I'll turn it over to Barry as he's going to be recognizing people that are raising their hands.
And Joanne Otton.
I actually have two questions, and the first question would be for Ms. Pearson. In cases of implied promises, some research suggests that implied promises can be dismissed by the courts as marketing puffery. When can you get an implied promise to actually be construed as a potential tenet of a contract?
Great question. So the contract will almost always say that all prior conversations are not part of the deal. The written contract will almost always do away with them as a matter of the written contract. So that's real. But you can sometimes say that there was a separate deal, and it depends upon the clarity of the deal. And that's why I say save those marketing documents. One of the truisms is that marketing people say almost anything to get you to sign, knowing that the contract is going to say, well, that wasn't the deal. But if enough people can show that there were these kinds of promises made, that's where you have clout. You're going to, in essence, be proving fraud. And that's where, and that's a high standard of law. Hard to prove.
Thank you. Thank you. And may I ask the second question? And this was actually a general question, and I don't know if perhaps the actuarial on board might want to answer it. But in terms of COVID, I know each marketplace is different, but how long is it reasonable to assign blame to COVID for underperformance in occupancy and financial performance?
This is A.V. Powell. The impact of COVID did create a spike in mortality rates, but I don't know if it's related to financial performance other than the fact it may have reduced the occupancy in independent living.
Does anyone know of a resource that might have compiled some type of methodology to forecast?
I don't know. This is Jack Cumming, who's also an actuary. I don't know of that kind of resource, but I think the main effect was to accelerate mortality among people who were frail. So I expect that as the actuarial data emerges later, you'll see some decline in mortality because it was accelerated during COVID. The COVID was very disruptive to the actual operations of the CCRCs, but in terms of the stochastic elements that AV can agree or disagree, but I don't think there's too much of a long-term impact there. I think right for now. I think when things go off the rails, there clearly are changes due to COVID. The sociability in the CCRCs has been reduced as a result of that, and that's slowly coming back. But I think that it's convenient to blame things on COVID, and people will look for blaming something other than taking responsibility themselves.
Okay.
We have a question from Patricia Birdsall. Please unmute Patricia.
It's usually at the bottom left side of your screen.
Okay, if you can't find the unmute, let's proceed with the rest of the program. Richard Ober has his hand up, and you need to unmute, Richard.
Yes, I just unmuted. A comment and a question. A comment, many CCRCs have offered life care plans which say if you move into healthcare, your monthly rate won't go up. And this is a good example of where maintaining the marketing material is very important, because in the one where I live, they now have a higher fee for people who have moved into the healthcare area, even though they had life plans. And I have my little binder with a legal opinion for me that they can't do that for me because I was before. My question is, who in New Jersey is the one in negotiations to acquire Spirit Trust Lutheran?
The company that's apparently interested in taking the Pennsylvania properties is Lutheran Social Ministries of New Jersey.
Thank you.
Patricia Birdsall now has unmuted.
Yes, sorry about that. I was a bit late joining the meeting, but my question is, are there any warning signs that you can tell when various services begin to cut back a little? Is that something that residents should be concerned about?
In my opinion, yes, they should be concerned about it. So one of the things that is sometimes happens is in contract law, ordinarily the contract is king. But if the contract is being changed through attrition, so to speak, for example, dropping skilled care, although you were promised skilled care would be a part of it. If you waive that, it'll be successful. But if you say, we do not waive that and argue against it, there's a concept that the only way they can make a change that's that fundamental to the agreement is through a new negotiation in which there's new consideration, a bargained for exchange, not a unilateral change. So watch out for unilateral changes. I make a distinction between if they're just changing to have the food be less expensive. One community did away with steak. Okay, that's in everybody's best interest financially. But if it's doing away with a level of care, boy, that's so essential to the life care plan. That's where I would definitely be saying, I don't like this and we need to talk and I'm not waiving my rights here.
Yeah, what I was thinking, nothing as significant as what you mentioned, but something small, like that isn't part of the contract, but it's just sort of something slightly different than what they used to do in allocating funds. As a, for instance, the residents are urged to support the Samaritan Fund and things like that. And recently, something was added in our community where if you didn't want to, you could donate to the Samaritan Fund, or you could allocate funds toward a program to sort of beautify the campus. You maybe change the carpet or collect money for something you want to do. And to me, that was sort of a beginning of a slippery slope. In other words, things that I feel they should be doing, they're now pushing that toward the residents to do. So it's nothing as significant as eliminating healthcare or anything like that. But I just thought that was that just concerns me. Let me put it that way.
Luana, do you want to turn to our next presenters at this point?
Yes, go ahead, Barry. We've got, I see a hand up from Regina, and you may have other people. So yes, continue for another few minutes if we've got interest going.
Are you calling on me, Regina? Are you
Yes.
calling on me? Thank
Yes.
you. Great. Well, I'm in California, in San Francisco, and I think I want to talk about the slow 1,000 little cuts, not the big change like we're getting rid of our nursing home, but just little things that affect the quality of life. Little things like we used to get our windows washed 4 times a year, now it's 2 times a year. We used to have 2 maintenance people on call or who worked here on the weekends. They changed that to 1. That wasn't discussed with the community. So I'm concerned about the pressures on the basic quality of life. How many times do your apartment get cleaned? They want to go from once a week to twice a month. Those are little things, and they're incremental, and they probably don't need a negotiation, but there has to be some vehicle to bring those up, and so that long-term residents don't get kind of their basic quality of life functions diminished over time by little cuts. Do you have any comment on how to grapple with that type of a situation?
Well, it could be a sign of distress in the community. So you'd want to be looking at all the other financials. So look at if there's any dips in occupancy rate and just pay close attention to the disclosure statements and the annual reports for your provider. And I think also the individual contracts are really important to what was promised to you in your contract. And then also you're talking about little cuts, but if there are bigger cuts, it may be that that you want to also look at the state CCRC law. So, for example, in San Francisco and California, we've seen some life care communities trying to get rid of their nursing homes, but that is actually in violation of the statute because they're required to have a nursing home on site if they're offering life care contracts. So ultimately, I think it comes down to organization and having a strong residents council to fight for this, and if it and potentially reaching out to advocates like California Advocates for Nursing Home Reform and CalCRA to reach out directly to the provider.
Can I add
Luana?
something to Yvonne? This is Pat McGinnis, and I was the founder of CANR, California Advocates for Nursing Home Reform, and I've been working on CCRC issues. One of the things we did, because the resident associations, as laid out in California statute, are really toothless for the most part. So we sponsored and got through a bill that's established resident councils and family councils for RCFEs. Every CCRC in California is also a residential care facility for the elderly. And so they get all the rights in that as well. What we found is that if you have a resident council under the law, the new law, and a family council, you have more rights in that, and the facility has to respond. But I will say finally that our biggest obstacle in California is our enforcement system. We really basically don't have an enforcement system. The Department of Social Services that oversees continuing care retirement communities has found 80% of the complaints to be unsubstantiated, even though it occurred, even though you can prove it. And we also have right now, the Attorney General has allowed Pacifica to take over two prominent CCRCs by Pacifica, which just filed bankruptcy as well. So we really have no oversight in California other than lawsuits. And the problem is if consumers and residents choose to file a lawsuit, they're going to be responsible for paying for the litigation fees. That's the opinion of the Department of Social Services. So we have a number of problems that we have to correct in California, and I don't know what it's like in the rest of the country, but I do know in California, CCRCs are in trouble.
Okay.
That's the end of the question, Solana.
Yes, that I want to thank everybody very much for their participation today. I think we've got a lot of good information. I want to remind people that NACRA has forums on our website. So if you are a NACRA member, you can post your concerns and comments on the forums on the NACRA website. I'd also like to say this conversation may be a very strong reason why you should join NACRA for $25 a year. We'd love to have you part of our conversation on the website. And I want to thank our speakers, AV Powell. I want to thank Catherine Pearson. I want to thank Yvonne Troya. And most of all, I want to thank all of you for taking your time today. And I again apologize for the slow upstart, but we're going to have 3 additional webinars, and I think we will get it together better next time. So start posting on the forums, join NACRA, and thank these wonderful experts for joining us today. Thank you very much.